Do that.
Yes, Bruce Plaza. Well, Chris, you might as well describe it again. The most interesting thing is the word appeal agreement.
Yeah, absolutely. Okay. Everybody hear me? So, previously, our ordinance number 1, 2013 adopted the International Property Maintenance Code of 2012. As permitted, several changes were made to the IPMC, and one of them involved replace section 111, means of appeal, with the creation of a board and hearing notices of appeal, with sending all appeals to the district justice. I reviewed that and recommended that we spread it out more, have an intermediary appeal level before going to court. Several other changes were made. We amended section 106.4 relating to violations and penalties, section 111 relating to a means of appeal, 107.7 relating to the notices to abate health hazards or public nuisance, and 106.3 relating to the prosecution of violations. We can go through the changes. Section 103.1, we deleted the existing one and spelled out who can enforce this. It now includes and defines the code official, which now includes the code enforcement officer, the zoning officer, code official, and any police officer or other duly authorized representative of the township. The previous definitions were limited. I wanted to give us some more flexibility. 106.4 deals with violations and penalties. Previously, the language was more restrictive. The thought behind this was to allow for all penalties permitted by the second-class township code. So it now limits that language. I also included language stating that rather than going to a district justice in an appropriate circumstance, we can seek an injunction from the Court of Common Pleas of Washington County. As Tom mentioned, the main change was section 111. This was a substantial change, but it was based on what's originally in the Property Maintenance Code. Essentially, if anybody receives a decision from a code official or a notice or an order, rather than appealing to the district justice, they have the right to appeal to the Board of Appeals of the township. It must be filed within 20 days of the decision, notice, or order. It shall be based on a claim that the true intent of the ordinance or rules adopted thereunder have been incorrectly interpreted. The provisions of this ordinance do not apply. The requirements of this ordinance are adequately satisfied by other means, or that the ordinance is invalid. It establishes a filing fee of $200, and it is basically to cover the cost of holding the hearing. In addition, the appellant, if they want a stenographic record to be taken of the proceedings, they also are responsible for that fee charged by the court reporter. Section 111.1.2, the contents of the application must be signed by the appellant, include the property address and tax identification number, the appellant's name, mailing address, phone number, and email address, property owner's name, mailing address, phone number, and email address, evidence of appellant's authority to act for the property owner, appeal. Whether they want a record of the hearing to take place, or whether they'd like it to be an electronic recording for which no such recording fee will be charged, a brief statement of argument or justification for the appeal, and any other information set forth on a form to be published by the township, if any. So in other words, if we put together a form, they can use that or supply the information on their own. Now, the membership of the Board of Appeals, the goal was to make it flexible. We do not want to be limited and to have a full-time board, be required to have a full-time board sitting at all times. It's permitted, but it also can be, in other words, if we don't have one right now, and someone files an appeal, the Board of Supervisors would have the authority to create one right away for that appeal. It will consist of between 3 and 5 members, and they shall be selected by the supervisors from a pool consisting of the Planning Commission, the Zoning Hearing Board, the Board of Supervisors, and the general public who are residents of the township. No township employee is eligible. The code official will be an ex officio member of the board, which means he or she is entitled to sit, but he may not vote on any matters. They shall appoint a chairperson, and any person with a personal, professional, or financial interest in any appeal should be disqualified from serving as a board. I'd recommend that they not be selected at the beginning. Alternates may also be appointed. Notice of the meeting upon receipt of an appeal. The supervisors shall coordinate with the Board of Appeals and then give notice as to the date, time, and location of the meeting to hear the appeal. It shall be heard within 30 days of the next regular Board of Supervisors monthly meeting following the filing of the application for appeal. And the reason for that language, so if an appeal was filed tomorrow, the hearing wouldn't need to take place until 30 days from our next meeting. Just gives us a little flexibility in case we have trouble getting together and deciding. And the appellant shall be given at least 10 days notice of the meeting. All hearings will be open to the public. Appellant, their representative, and the code official, and any person whose interests are affected shall be given an opportunity to be heard. A quorum shall consist of a minimum of 3 Board of Appeals members. That means that if the board consists of 3 people, all 3 people have to be there. If it's a 5-person board, then only 3 members have to be there. Hearings are governed by the local agency law and the applicable provisions of the Pennsylvania Sunshine Act. Strict compliance with the rule of Pennsylvania Rules of Evidence isn't required, but there's no need to accept everything that isn't relevant to the appeal. The board will modify or reverse the decision of the code official by a vote of the majority of the Board of Appeals members. And the decision shall be recorded and furnished to the appellant and the code official. It's not going to be stenographically recorded. It needs to be electronically recorded. And as we mentioned earlier, the appellant may request that it be stenographically recorded if the appellant is willing, agrees to pay the appropriate cost. And then it clarifies if the appellant doesn't want to pay the cost, the Board of Appeals is able to have it to make sure that it is stenographically recorded. So the appellant has the option to make sure it happens, but they can't prevent the board from making it happen. And the code official shall obey the direction of the Board of Appeals. Court review. Any person aggrieved by the adjudication has the right to appeal to the court with appropriate jurisdiction, which is the Court of Common Pleas of Washington County.
Chris, earlier you referred to the district judge. Would they be a step in the process if the applicant or the appellant wants to go there?
No, their appeal for this would be to the Court of Common Pleas. If you issue a notice of violation and that isn't challenged, but they just don't comply with it, then we enforce the fine in the district justice.
All right, so that's 106.4.
Yes.
But if they appeal to be
But
just
if
this
they're
court,
going, yeah, if they're going to appeal the notice, saying the notice doesn't apply to me, it comes to the Board of Appeals and then up to the Court of Common Pleas.
all right, again, can they choose to, they can choose to waive this court, this appeal process and go straight to common pleas? Or is it a required step?
No, they do not, they are not required to take advantage of it.
Does it say that in there that they can go, you know?
I don't think it does, but this is this is their protection, so they don't waive anything by not doing it.
So they basically have the option. They could go through this process, or they could go to common pleas.
It's different, if you're saying you shouldn't have issued this notice of violation because, I don't even...
Say it's high, let's just use that for an example.
Right, so, if we, as we say, and the only thing they're allowed to appeal is that, so say you give a notice of use violation, and he says, well, the ordinance is invalid for X, Y, and Z. That's something you can challenge the Board of Appeals. But if his argument is that my weeds are only 5 inches, not 6 inches.
No, they're no weeds, they're flowers. So
Yeah,
use
something
argument
like that.
They're,
And the zoning officer or the code official is applying it wrong, then, here, one second. Yeah, then so if you said you shouldn't have issued the notice of violation, it would come to the Board of Appeals. If he forgets to do that and gets cited, then he would appeal, then we would be in front of the district justice enforcing it. So this is mostly for the notice of violation. When you send the letter, it would, if you wanted to challenge that letter, it comes to the Board of Appeals, because you wanted to find it. But as soon as you cite them, then we're in front of the district justice. Does that make sense?
yeah.